Dear students, let us start the discussion on today's newspaper, that is 9th April 2016 newspaper. The first article is related to the Supreme Court and judicial reforms. Now, recently, we are seeing many articles on National Court of Appeal to decrease the burden on the Supreme Court. If you clearly observe the constitutional role envisaged by our forefathers to the Supreme Court includes a role as a final interpreter of the Constitution and also as a protector of the Constitution. So in this context, if American Supreme Court and Indian Supreme Court are compared to each other, Indian Supreme Court are given much wider powers. So this is majorly to protect and to safeguard interests of the citizens. We can broadly divide the functions of the Supreme Court into two categories. One is virginal jurisdiction, the other one is appellate jurisdiction. Under the virginal jurisdiction, you can directly go to the Supreme Court for a matter. On the appellate jurisdiction, they come through a hierarchy of the courts to the Supreme Court. In this case, the primary function is the virginal jurisdiction is to resolve interstate disputes, interstate disputes, etc. And added to this, it also shall protect the rights of the citizens, and any writ petition comes to it, it has to accept that. On the other hand, the Supreme Court takes up many of the cases through appeals and also special leave petition. So today, if we observe, most of the time of the Supreme Court is spent on trivial issues rather than the core constitutional matters. Now, as per Constitution, a constitutional bench shall consist of more than 5 judges to adjudicate on a particular matter. From 1947 onwards till date, if we observe, the number of the cases adjudicated by 5 judges bench are decreasing over a period of time. It was around 15% in the initial years of independence. Now it is less than 0.12%. It is due to lack of sufficient number of judges and also the workload over the Supreme Court. So, if you observe the Nas Foundation case, where the Supreme Court has adjudicated the Section 377 as still valid, and it has reversed the judgment of the Delhi High Court and made homosexuality a punishable offence. And if you talk about Section 66A of Information Technology Act, and Supreme Court doing away with that in Shreya Singhal versus Union of India case, everywhere they were adjudicated by 2 judges. So it means that 2 judges, 2 people at the highest position of the power, they can change the Constitution and interpret the Constitution to their will. So generally it is expected that wider benches have to take an opinion on the important constitutional matters. So what is being proposed is this. In between the High Courts and Supreme Courts, a National Court of Appeal will be constituted. All the criminal and civil appeals will be directed to this court, and this court will have regional benches. So in this case, the burden of the Supreme Court will tremendously decrease and it can focus on core constitutional cases. If it has to be brought in, a structural change and an amendment to the Constitution is necessary. And the second thing is, the real problem of judiciary in India is not in the structure, but how it manages the cases. If you observe National Judicial Data Grid, what it clearly states is more number of cases are getting accumulated at the lower level of the judiciary. The lack of the capabilities of functioning at the lower level of judiciary and huge level of corruption, these need to be addressed first. So, we can welcome the National Court of Appeal, but at the same time we also shall bring in a reform at the lower judiciary. So what the author is recommending is a bottom-up approach with regard to the judicial reforms. Now coming to the waste, the solid waste management in the urban areas. So the Ministry of Environment and Forests, it has given a new set of rules with regard to the solid waste management. Now in this context, I will be discussing the solid waste management rules as the new articles come by. For the time being, understand the intensity of the problem in India. Any solid waste management, it has 3 important steps. First one is collection. At the collection level, the solid waste has to be segregated into recyclable and non-recyclable. And after that, it has to be transferred to a particular place where it will be recycled. And finally, the treatment of the solid waste. Now, at these three steps, we can see a failure. The citizens were not properly educated about the separation of the solid waste, and there is no incentive or punishment for failing to segregate the solid waste at the collection level. And the distribution level, it is mostly through the open trucks. Because of this, that particular pollution is getting distributed throughout the urban areas. And finally, at the recycling point, less than 1/3 of our total solid waste is actually treated. So what is the most common method we follow is the landfilling. If you landfill with the solid waste, more than 1200 hectares is necessary for the urban solid waste management every year. So in many of the suburban areas, you can see the heaps of the solid waste, each up to the size of a mountain. Recently in Bengaluru and Mumbai, especially with regard to Dionor landfill in Mumbai, there's a huge fire accident which has led to the pollution in the Mumbai. So it means the solid waste management is critical for the urban areas. So what are the various methods followed? At the segregation level, you have to separate from the individual households from the large solid waste accumulators like hotels, restaurants, etc. So you can develop then and there itself the recycling, composting, biomethanation, these plants. And with regard to the distribution of the solid waste, a decentralized recycling management can be adopted rather than managing that one single place. So this will reduce the effort and time in managing the solid waste. And finally, the landfilling and plastic waste getting accumulated over here, it is costing a huge with regard to the biodegradability. So in this context, the next article, it talks about the technology towards treatment of the solid waste. So there is a biomethanation as a technology. What exactly it means? The solid waste is converted into biogas through this biomethanation. But however, most of the solid waste in India is organic. So the low calorific value of this solid waste makes it economically unremunerative. So Department of Science and Technology now is looking into the appropriate technology that can treat the solid waste in India. Coming to 400-year-old ban goes. Now, women entry into the temples in the name of the customs. Women, especially women who are menstruating, so these people are not allowed into the sanctum sanctorum and saying that it is impure. So, happy to bleed or free to bleed, there is a campaign which is going on. So according to this, so there is nothing called purity and impurity in a biological function. So whatever the customs which are being developed in a religion, they are based on certain circumstances. So in this context, if you see the constitution, the right to equality and the freedom of religion, they appear to be conflicting with each other. Can the state interfere with regard to the religious affairs? Or the state has to uphold the equality rights is the major question. In this case, as per the directive of the High Court of Bombay, the Shinapur temple has allowed the women into the sanctum sanctorum and allowed them to pray before the God. So it is a victory for the gender equality in India. And coming to another killing in Bangladesh, you know that Bangladesh is a secular nation, but however Islamic elements are on rise. And after the war tribunal has punished them, the war criminals of 1971 liberation war, the Islamic elements have taken further onto a dreadful course, killing the bloggers who are promoting for the free speech and expression, and talking about protecting the secular credentials of the Bangladeshi state. So this is an intolerance which is growing in the Bangladesh, and the state is doing nothing. That's what this article exposes for. And coming to the China's internet censorship, out of the 10 most trafficked sites in the world, the 6 are banned in China, including Google, Facebook, Twitter, etc. So it is affecting two ways the international business. One, The internet giants, they are unable to get their revenue from a massive economy and a huge market. And the second thing is, so many of the other companies, they are unable to transact freely and seamlessly with the Chinese companies. So the chain of fears that open internet can destabilize it, especially in the Arab Spring and the post consequences. The Great Firewall was further strengthened, and much of the traffic which is coming from outside to China is being screened. Even if you observe the Panama Papers, they are being banned from disclosure on internet in China. And coming to the Indian Express newspaper, there is a very good article over here with regard to the tax evasion in India. Now understand, the tax evasion and tax avoidance are these two different things. The tax avoidance, it means the people are not paying the taxes by using the loopholes in the tax laws, or by using the various agreements that exist between the countries to stock their wealth in the tax havens. On the other hand, tax evasion is blatantly not paying the tax, which is a punishable offense. So today the major problem is the tax avoidance. Now in India, if there are two major problems over here, too high tax rates. So if you club all the direct taxes together in India, they reach up to 50%. And the second thing is complicated tax laws and the capital controls. The capital movement across the boundaries is critically reduced, or else there is no proper clarity on the capital movement across the border. If you talk about liberalized remittance scheme of RBI, it allows for the movement of $250,000 or more outside the borders. But what it has to be used for? Can offshore companies be established with that? There are no clear rules in that particular perspective. So the clarity of the legal framework, this will minimize the tax avoidance. Now if you carefully observe the GAR rules, General Anti-Avoidance Rules. So please refer to this to your economy notes. General Anti-Avoidance Rules is very important for this year's exam. So the GAR rules, if are enacted and added to the direct taxes code if it is implemented as soon as possible, and the simplification of the tax regime is undertaken, then automatically the tax avoidance will come down in India. So along with this, the Money Laundering Act, and India being the part of the Financial Action Task Force, then there is a good, already there is an enough legal framework to control the money laundering or money moving out of the boundaries and leading to the crime. But however, the money moving out under the legal route and legal loopholes is the major problem. So next is OECD countries, though they have a simplified tax regime and liberal capital movement, in spite of this, the resort to the tax havens is undertaken. So a series of steps which have been taken up by the OECD countries, one among them is automatic exchange of information, an agreement on base erosion and profit shifting. So this agreement on base erosion and profit shifting, it prevents the companies choosing to move to the tax havens to pay the taxes over there. And added to that, the Foreign Account Tax Compliance Act. So this is the United States law. Under this, any of the citizen of the United States, if he has any law or any account abroad, then the country has to automatically share the information with the United States. So these are the various three laws, three mechanisms which are taken up internationally to fight this particular menace. And coming to the Modi Sharif opportunity, this article has just listed what are the events which have happened with regard to the Prime Minister Modi and Prime Minister Sharif's engagement is concerned. You know that as Prime Minister Modi, during his ceremony, the swearing-in ceremony, he has invited all the SAARC countries, including the Prime Minister Sharif. And Prime Minister Sharif visited or taken this invitation in positive light and visited India, which has given a good hope for the engagement between these two countries. And after that, the suspension of the Foreign Secretary level talks, and when the Foreign Secretary of Pakistan insisted on meeting the Hurriyat leaders, and after that WUFA summit has occurred, in the WUFA summit, there is an indirect mention of the terrorism and indirect mention of the Kashmir, which did not go well with the Pakistani establishment. Finally, the NSG level, National Security Advisor, NSCA level talks were suspended. And after that, at the Paris climate change meet, both the prime ministers met for a minute, and then the Prime Minister Modi's visit to Lahore, and then National Security Advisors meeting in Bangkok. All these are the series of events followed. And after that, the Pathankot terrorist attack, so that has derailed the process again. An entire engagement was kept on hold. But minimalistic communication is happening between the National Security Advisors. So in this context, what the author recommends is the non-state actors shall not determine the state engagement between India and Pakistan. So this is the essence of this article. So this is about today's newspaper. Thank you very much.